Stijn Huijts, Helene Andersson, Ben van Rompuy. Everyone, welcome to Digital Markets Research Hub. We will be talking today about the trilogy or hat trick. Many peers have used all the metaphors already of cases delivered by Grand Chamber of the Court of Justice in late December 2023. All are related to sport, to professional sport, but also to EU law more generally and to EU competition law more specifically. And you all three are experts in competition law sensu stricto, but also in understanding how it interacts with other EU areas of law, but also with professional sports. So I wanted to use this opportunity to learn from you. Even if my first PhD was related on sports media rights, it was ages ago. So let us maybe revert to the issues by using the first round as a factual reminders of the case. Helpfully, we have three cases and we have three experts. So I propose maybe we can start with you, Stijn, outlining to us the Royal Antwerp case.
Yeah, very happy to do that, Oles, and thank you for the invitation. So this is a case that is about homegrown players and rules on homegrown players. And essentially, those rules are about saying that on a match sheet for a professional club, a certain number of players have to be homegrown, so trained by the club itself or by a club in the same National Football Association for a certain period before they turn a certain age, usually 21. And there was one player in Belgium who challenged those rules, in particular the rules by UEFA and by the Royal Belgian Football Association. And he challenged them in arbitration proceedings, and he was joined by his club, Royal Antwerp. That's why this judgment is called Royal Antwerp. Now, that arbitration proceeding does really led nowhere for the player and the club. And they then challenged the arbitral award to a Belgian court, and the Belgian court put questions to the Court of Justice. So that's how we ended up here. And this is essentially the preliminary ruling from the Court of Justice on those questions. And I think the main part of this judgment that is interesting to discuss is on Article 101, and in particular whether these rules on homegrown players are restrictions by object, which, to be honest, having been a competition practitioner for a while and having also worked for both competition authority and in private practice, was not that obvious to me, but it is the lens through which the court approaches that rule in the first place. And I think it's an interesting area to quickly dive into. So what the court says essentially is, as we all know from studying competition law, that of course, object restrictions are types of coordination that are very bad for competition. They reveal a sufficient degree of harm to competition, to use the words of the court. And because they do so, because it's already clear, you don't have to assess their effects. Now, the court says, of course, that applies to horizontal cartels, but it can also apply to other types of coordination. And there they say, for example, where the conduct leads to the exclusion of competing undertakings. And the relevant case law there is actually from the pharmaceutical sector, so the pay for delay cases, or where they are decisions by an association of undertakings that give certain recommendations to the members of the association that restrict competition. And the court also reminds us, and this was an area of competition law that in which there weren't really very many cases recently, but the court says it's also an object restriction where coordination essentially leads to the partitioning of markets according to national borders. And here Of course, it's very important that within the EU, one of the goals of the EU is to have an integrated internal market. So agreements that lead to a partitioning of the internal market are also seen as particularly bad. So how does that translate to the rules on homegrown players? And I have to say that here I find that this the least clear of the three judgments that we're discussing today. So thank you for allocating this one to me. I think that, first of all, of course, the court recognizes that organizations like the Belgian Association or UEFA can set rules for the competitions that take place within Europe or within a country. That is all fine, but those rules should not lead to restrictions of competition. It looks then specifically at these rules on homegrown players, and it distinguishes between two levels where competition takes place. The first one is the recruitment of talented players. And essentially the court says, clubs engage in competition to recruit players, and the better players would enable them to win games. And the court sees that as an upstream market. And then it also recognizes a downstream market, and it says that this is a market constituted by inter-club football competitions. Now, I find both of these quite difficult to assess within the sort of object box. So on the first one, I do see that you would have a kind of purchasing market on which clubs are active and where they would be recruiting players. And here you would have a decision by an association of undertakings, the undertakings being the clubs, and the association being the Belgian Football Federation or the UEFA. But then looking at the restriction of competition, I think it's in a way quite difficult to see immediately, as you should be able to do, that here there's a restriction of competition by objects, because on one hand you can say that the clubs are not necessarily better off because of this restriction, right? So normally if you have a restriction of competition, you would say that the competitors are putting themselves in a better place than they would be in the absence of the restriction of competition. But that is not necessarily the case here, because they have access to fewer foreign players to fill their match sheet. But of course, we're also always concerned about the structure of the market. So it doesn't just stop there. Perhaps we can find a restriction by object if we look more at the structure of the market. But even there, I would say, this rule kind of goes in two ways. On the one hand, yes, artificially they're making the number of places available to foreign players more scarce, and therefore those players their bargaining position is worsened. But at the same time, when there are fewer places for those players, competition for the very best ones becomes even stronger, and so they might be able to command higher prices for their services, so to call them. So I think the point that I'm just making, and I think we can have a long debate about this, of course, but I find it hard to see, without assessing the effects, why this type of coordination would reveal a sufficient degree of harm to competition. And then finally, the second market, I really do find this judgment lacking in detail, because it doesn't go further than those three words, inter-club football competitions. And there I am just quite unclear what market we are talking about. Is this a market between different leagues, where the Belgian league would compete with the Premier League? Or is this a market where we're talking more at a club level, but are we then talking about their competition on the pitch, or their competition for other things like advertising revenue or selling rights, etc.? the judgment doesn't give any detail on this, and what we're left with is essentially the court saying to the national court, who asked questions and asked for this preliminary ruling, basically, you national court, you need to look at what these rules do to access to football players. You should equate that to access to essential resources, and you should look at to what extent these rules limit access to those essential resources to such a degree that it would be a restriction by objects. Now, as I say, I find that quite unclear, and I think the other two judgments are a lot clearer in their application of competition law. But I'll leave it there.
Thank you very much, Stijn. And we will try to decode this so many interesting issues which you have summarized to us during the next hour. But let us move to the second case, to the Super League. Helen, please.
Yes, thank you, and thank you all for inviting me to take part in this discussion. Well, the Super League case also concerns football. I guess most of you are aware of that. And this time, I think it was 3 years ago, we had an announcement that we would have a new league in Europe, the so-called Super League, consisting of, I think it was 12 to 15 clubs. They were joining in what was called the Super League, which I would say differs from other leagues in that it would have permanent members. So these 12 to 15 clubs would be permanent members of the Super League, and they would also be qualifying members that would be, rotating, but we would have a number of permanent members. And this announcement, I would say, I'm not that into sports, but my son, it's like a bombshell when it came. And I think it was also a bombshell to the International Football Association, the FIFA, with its regional European branch, the UEFA. And FIFA is a private body. It has its headquarters in Switzerland, and it has statutes which gives it powers to its members have to authorize any competitions, inter-club competitions by its members, and it also engages in the exploitation of any rights deriving from such competitions, and we know that they can make quite a lot of money from that exploitation. Well, FIFA was not really that happy with the announcement that we would have a new league. And what they did was that they said that they would not recognize the Super League. And also they would expel any club or any player that took part in competitions organized by this new league. Okay. And which of course made some of the clubs quite frightened, and also made the organization turn to the Spanish courts and complaining about this, that it was contrary both to the competition rules but also to the rules on free movement. And of course the Spanish court could not really deal with this question without having to turn to the Court of Justice. And I must say, when I read the ruling in December, I was quite surprised because, normally you have a few interveners in a case, some cases more important than others. You have a great number of interveners. But in this case, I think we had 20 member state governments actually intervening. So I guess it's really important, this ruling and the game of football. And the court, in its ruling, had to assess whether the actions taken by the organization was contrary to Article 102, Article 101, and also the rules on free movements. And in its ruling, it starts out with assessing the applicability of Article 102. Saying that, establishing that the association does indeed have a dominant position, and also the fact that this organization, or if you are an organization which basically has the power to determine which undertakings that are to enter the market, and also on which conditions such actors are to be active on that market, we will have to assess Article 2 also in conjunction with Article 106 of the Treaty on the Functioning of the European Union, which we all know concerns public undertakings or undertakings that have been granted special or exclusive rights. And what the court says is that if we have a dominant undertaking with these powers, basically to determine who should be able to enter the market, and also in a case like this, when that undertaking or association of undertakings is actually active on the market itself, and therefore that there is a conflict of interest, it's really important that there are clear, transparent, precise rules governing, for example, the authorization of competitions or so on. And also that these rules should not only be clear, precise, and transparent, they should also be applied in a non-discriminatory manner, and they should not be applied arbitrarily, and they should be accessible. They should be there before a decision is made, and they should be accessible to in this case, well then, the Super League. And the court says in the case we don't have these rules, or if they are applied in a manner that is arbitrary or discriminatory, that in itself constitutes an abuse of Article 102. What more? So we should have, and also a procedural framework that should surround this, that should also be clear and precise. And in this case, the court says, well, there are no procedural safeguards at all. So basically what the court says here, and also is that the court says that, of course, there may be objective justifications, but that will be for the national court to sort out whether there are any such objective justifications, although the court is quite clear, I would say, that it doesn't really consider there to be any such justifications. Then the court moves on to Article 101, and again, it does not really have any problem in establishing that the fact that we have an association here without, again, which has a power to actually effectively cut someone out of the market, and in case there are no rules governing this, this would constitute an infringement also of Article 101 TFEU. And the court says not only would it constitute an infringement, it would also be an infringement, just as in the case of Royal Antwerp, by object. And as it would, if you are able to effectively cut someone out of the market, that will cause enough harm for it to be a by object restriction, and then there is no need to look into any effects. And this, the court says, will also have as an effect, if it's a by object infringement, we cannot really justify it. There could not be any legitimate justification of this, which would take the actions by FIFA outside Article 101. Again, we could, inside Article 101, assess whether the criteria for exemptions are fulfilled, but it's not possible to say that it's not restrictive competition at all. So leaving it again to the member state to assess whether Article 101.3 would be applicable, it gives the national court, I would say, some quite clear hints on how it should make such assessments and what conclusion it should draw from that. And it also, finally, the court looks into the question of whether this is also contrary to the rules on free movement, which we know are not really directed towards undertakings, but instead to the member states. And here, of course, there are different freedoms that could come into play. We have the free movement of workers, we have the freedom to provide services, and the court says, well, in a case we have two or several possible freedoms to assess a measure by, you would go for the one that is actually the predominant one. And in this case, it would be the free movement of services, or the freedom to provide services, I should say. And the court says that in this case, given the fact that there are the member states have not adopted any clear rules, transparent rules, there is no procedural framework surrounding these kind of competitions or authorizations to participate in or set up international inter-club competitions, it has actually left it to FIFA to do what it wants, and that in itself could constitute a breach of Article 56 of the treaty. So that basically is what the court says here. And I should say also that, as far as I understand, it's those 15 clubs are now 2 clubs remaining in the Super League, and I think that's 2 Spanish clubs, and that the Super League has now said that we'll look over things and perhaps make it to something else where clubs should be actually qualifying to participate, and we should not only have men and women, not only have men but also women participating in these competitions.
Thank you very much indeed, Helen. Ben, now let us revert to the third case, to the facts of the third case, please.
All right, and first of all, also thank you very much for the invitation. Also a disclaimer that at least at the early stages of this case, I was personally involved in it. I'll explain how. The ISU case goes back to 2014, when for the very first time a third-party organizer wanted to organize alternative speed skating events. That had never happened before. And the organizer wanted to kick off with a series of annual events in Dubai leading up to the World Expo. Now, the International Skating Union, which is the international sports governing body for figure and speed skating, sent a communication to all of its members, reminding them of its eligibility rules. And at that time, the eligibility rules stipulated that for athletes, if they were to participate in an unauthorized event, they would become ineligible for life. So that means a lifelong ban from their sport. It also added in that communication that it would not authorize these events in Dubai. Now, sports betting is prohibited in Dubai, but future events of that same organizer might have a link with sports betting, and coincidence or not, the ISU had just adopted a new code of ethics prohibiting any link with sports betting. I remember reading this in the Dutch press, and I wanted to write something about it. I didn't know anything about speed skating, but I thought I saw a competition issue. And I emailed the coach that was quoted in that article. That got passed around, that email, and I got the question back, what are you talking about and what can we do? And then the idea came, well, I guess I can write a complaint. And then together with Antoine Duval, a colleague of mine at the time, we wrote a complaint and filed it with the commission. And I then represented the 2 complainants, Mark Tuitert and Niels Kerstold, 2 speed skaters. So that was my involvement in the case. Now, in 2017, the European Commission adopted a prohibition decision, and it concluded that the eligibility rules constituted a restriction by object and couldn't be justified for the same reasons as Helene just discussed, because they were not connected to a pre-authorization system that was non-discriminatory, objective, transparent. In fact, there was also no authorization system when the Commission opened its investigation. Interestingly, the Commission also looked at the ISU's arbitration rules. And the arbitration rules, they stipulate that any decision of the ISU, so including decisions on ineligibility, have to be appealed to the Court of Arbitration for Sport in Switzerland, which is an arbitral tribunal, and it mostly acts as an appellate body. So decisions, final decisions by sports governing bodies can be appealed to the CAS, to that Court of Arbitration for Sport, exclusively. And the Commission reasoned that imposing such an arbitration system on athletes would make it more difficult for athletes to actually challenge possible anti-competitive ineligibility decisions, because they wouldn't have direct access to the civil courts. They would first have to go to Switzerland. So therefore, the Commission concluded that these arbitration rules, although not part of the infringement, reinforced the anti-competitive effects of the eligibility rules. Now, that decision was appealed by the ISU, and the General Court largely upheld the decision of the Commission, but it did take issue with that part on arbitration. And it made 2 points. First of all, the General Court reasoned the European Commission had said to the ISU, if you were to keep your pre-authorization system and your eligibility rules, then you should also substantially alter your arbitration rules. And the General Court said, well, this was not part of the infringement, so therefore you cannot ask for corrective measures in relation to something which is not part of the infringement. So the Commission couldn't have asked for a change of those rules. But it went a step further, and it said that the Commission couldn't even have considered that these arbitration rules reinforced the restrictions of competition, because it highlighted there's legitimate objectives why you impose exclusive arbitration on athletes. You know, there's good reason to have a uniform worldwide dispute resolution mechanism. But it also reasoned that the effectiveness of competition law would not be undermined, because athletes could still initiate ex post damages actions in front of the courts, or go to the competition authorities, as what happened in this case. That judgment was appealed again by the ISU on the question of whether there's a restriction by object or not. The Court of Justice dismissed that appeal, confirmed that there was a restriction by object, once again for the same reasons as discussed. But then it annulled the part of the judgment of the General Court on arbitration, because the Court of Justice emphasized, you know, arbitration is a legitimate dispute resolution mechanism. Therefore, judicial review of arbitration awards should be limited. This is the eco-Swiss jurisprudence of the court. However, that review must ensure also compliance with EU competition law, because Articles 101 and 102 are part of the public policy of the EU. So therefore, compliance with these provisions must be secured. And here is the problem. The arbitration rules provide you have to go to the CAS in Switzerland, and you can only, or the only court that can review CAS awards is the Swiss Federal Tribunal. Now, the Court of Justice says, so the reviewing court must be able to assess compliance with EU competition law and must be able to refer preliminary questions to the court. In case of doubt, well, the Swiss Federal Tribunal does not consider EU competition law and cannot obviously refer questions to the Court of Justice. So therefore, the Court of Justice said that the General Court should have taken this into account and should have found that the arbitration rules actually are problematic in the sense that there's not an effective judicial review. It annulled the part of the judgment of the General Court, also criticizing the court for thinking that the other legal remedies would actually compensate for the lack of effective judicial review. So it annulled that part of the General Court's judgment, and then it gave final judgment in the matter, going back to the appeal initially of the ISU against the arbitration part of the Commission decision. And for the very same reason, it actually agreed with the European Commission that this reinforced the restriction of competition identified, and therefore found that the Commission was right in asking for corrective measures also in regard of the arbitration rules. So at the end of this case, the Commission decision was upheld in full.
Many thanks, Ben. Let us now revert to more than to the implications of these three rulings on the system of sports governance before looking at competition law implications. And we know, thanks to your taxonomy, very helpful, Ben, that the relationship are very mature and very heterogeneous. Yeah, we have a very complex labyrinth of different implications, starting from the issues related to regulation of individual sports and conduct, such as anti-doping, match fixing as examples, regulation of employment, regulation of club management, regulation of economic relationship between sports actors and other actors, commercial activities, and these are interact with each other, and the implications, we obviously don't aim to cover everything, but Stijn, you have mentioned in our communication that some mature jurisdictions plan to introduce alternative regulatory or quasi-government control over the most or the premium professional sporting competitions. So maybe you can pick some issues which in your view resonate most with the spirit of the judgment, and where these judgments introduce significant paradigmatic changes.
Yeah, I'm happy to go first on that, but I think the other speakers will probably have some more insightful views as well. And you know, I think actually in Europe we've created quite a difficult you know, position for football clubs and football associations when it comes to competition law, right? Because here we have organizations that quite legitimately, of course, have to set rules of the game, but those rules do have an impact commercially. And then where do you draw the line as to what is legitimate and what is not legitimate? That can be very difficult. And it becomes even more difficult, I think, where in fact, those organizations also organize an extremely lucrative tournament in the form of the Champions League, for example, which would compete with rival leagues, which it, you know, considers it can regulate. So, you know, we have for a long time not really had any sort of government regulation of these competitions. And we have asked for industry participants to regulate this themselves. And, you know, they have taken certain decisions which are totally neutral to competition, but certain decisions clearly where they've strayed into, difficult positions or unacceptable positions from the point of view of competition law. But I don't think that, you know, compared to like cartels, where you can really see the sort of bad intent of the participants, I don't think we're quite in that kind of world here. You know, I do have some sympathy for the difficulty, you know, for how difficult it is for the participants in these decision-making bodies to get it right. And particularly if you look at something like the Super League, I mean, politicians were all over that. I can see why UEFA and FIFA felt that they had to act decisively against the Super League, and felt that they had political backing for doing so as well. That being said, you know, I think it shows us a little bit as well why form of regulation may not be a bad thing. And as I pointed out to you, Oles, over email, in the UK, they are looking at that, and they will be tabling a bill very, very soon, I understand, to introduce a football regulator, which would look at aspects like the ones that were under consideration in these judgments, including, for example, you know, whether a rival league can be set up and what the conditions would be that would apply to such a rival league. And I personally don't think that is a bad thing. I think a little bit more clarity is probably desirable.
Thank you very much, Stijn. Helen, how do you see this relationship?
Yeah, I agree with you, Stijn, that I think that some more regulation would be welcome. I think. I mean, and also what the court says here is that you are actually competing with the Super League yourselves, and you need to have clear rules. That's what they criticize FIFA and UEFA, not having these clear rules for what is required for an authorization and what is not, and also for the member states that they don't regulate this themselves. And I can see that this. I don't have anything to object against that. Then I don't know the outcome in this case, whether the Super League should have been allowed or not. I'm really not the one to say anything about that, but I think just a requirement to have a clear standard, and to me that resonates well with me. I don't really have any objection against that.
Many thanks, Helene. Ben, I remember the days when the 3+2 rule was considered as a kind of a norm which protects the spirit of professional football sport, or kind of national identity of club competitions. Now it looks like a very, almost prehistoric constraint. But for homegrown players, was considered as a kind of workable compromise for more than a decade after Bosman. Now it appears to be challenged as well, so it's not enough by far. Does this observation epitomize the broader trend of trying of European Union law and European public interests intervening more systemically and more proactively into this autonomous system of regulation? Is it a broader trend, and what are your views about this?
That's a big question. First of all, perhaps I don't think in essence what the Court of Justice is doing here is so new, in the sense that we haven't had a lot of jurisprudence, but the court has always been sensitive to sport-specific considerations. But evidently, it only gives autonomy to sports governing bodies to the extent it's conditional on compliance with EU law. And there hasn't been so much scrutiny. I mean, in the past 2 decades, the Commission opened 1 investigation, and we haven't had a lot of court judgments. But I think, the competition law has a very useful, in my view, role to play as imposing a sort of constitutional check on these sporting rules and practices. And in principle, the demand is reasonable, I think. They would have to show that the restrictions they imposed are inherent and proportional to a legitimate sporting objective. And so far, sports governing bodies have been able to do that. There haven't been a lot of successful competition law challenges against sports governing bodies. I think in these cases, certainly the Super League and ISU, these are perhaps extreme cases. The court actually acknowledges that an entity like UEFA can exercise gatekeeping power, and it can actually control market access. But then it comes with the condition that it has to be neutral, right? There has to be actually a virtual separation between its gatekeeping role here and its commercial interest. But to me, it makes sense that those demands are imposed because of the risk of market foreclosure in this area. So the court is critical of the rules in these 2 judgments, but there was no framework whatsoever. So I do understand why that is problematic. So I don't think this now means that every sporting rule can get challenged and can successfully be challenged. It's still going to be difficult to bring a competition law challenge. Maybe I should also add, it's true what Stijn says, that it's obviously difficult to draw the line between when is a sporting rule legitimate and proportionate and when is it not. And I think we should also give deference to the sports governing bodies there, because they have the expertise, etc. So you're only going to find a competition law violation when it's blatantly wrong. But there, I think actually private actions in the national courts are less suitable, and that competition authorities actually have a role to play. I can give the example of the Bundeskartellamt, for instance, who looked into the advertising restrictions that the International Olympic Committee imposed on athletes that participate in the games. So then the question was, how much opportunities should Olympic athletes have to showcase their own sponsors when they participate in that event? What is fair? That is a very difficult assessment. I see also difficulties in a court making that call. So what the Bundeskartellamt did is they sent out surveys to 500 athletes. They sent out surveys to potential sponsors. They then had commitments. Those were market tested. There was feedback of all the stakeholders. And then there were new commitments. So it created a forum, a space for all stakeholders to come together and to find a solution. That's something where public enforcement obviously has an added value in scrutinizing, the proportionality and acceptability of these rules. And I suppose what the UK is trying to do does a similar thing. You create an independent regulator that also opens a forum, an inclusive forum, where all stakeholders, also fans, also athletes, can contribute, and probably you get better governance as a result of it. It just also has its limits, because I mean we're talking about a global phenomenon, global rules, so it's very difficult at a national level with national laws to try to regulate that, because you also want a level playing field, right, across the EU. So I guess what the UK is doing is interesting and has its function. I think actually competition authorities scrutinizing these rules could perform a similar function in a way, but it's always going to be ad hoc. So it's I guess the second best solution.
But as a follow-up on this UK stuff, before reverting to Article 165, I wonder, don't you think that it's very plausible that they would be adhering to the agenda of UEFA and FIFA against the Super League, claiming that it's all-inclusive nature of promotion relegation system, and it's it reflects, manifests our values, universal, so kind of not being the locomotive of changes, but on the contrary, trying to provide the rubber stamp, the official rubber stamp to the status quo, reaffirming to the system of UEFA and FIFA.
Yeah, look, I think that is certainly a possibility, and in the UK, having lived there for a while. Not anymore now, but I think there is a strong sense that there is, specific UK culture involved in football, which has led to the emergence of the FA, which has set the rules of football, which the world has later adopted, right? So there is a strong sense of national culture, I think, within UK football, and that will certainly also play a role in this regulation. But taking my competition hat off for a moment, I don't think that is improper, right? I think for a government with a democratic mandate, you can take other considerations into account when you're setting regulation, which a competition authority would not take into account. And that is fine. You can do that in national laws. Of course, within the EU, it would be slightly different. You can't adopt laws that would make Article 101 ineffective. But still, even in Europe, we have in other areas of culture, music, for example, we have rules in France on what percentage of music played on the radio must be French music. That is fine from a cultural perspective, so long as it comes from a government, I think, right? And it becomes a lot more difficult when self-regulated bodies try to introduce such things, because then, as Ben said, competition law kind of applies. And yes, you have your exemptions. You have your 101(3), you have your Wouters exclusion. but those are in practice very difficult to apply. And let's be honest. I mean, to find a lawyer who will write a legal opinion saying, yes, this restriction complies with Wouters or with 1013 will be very difficult, because it is so hard to assess that ex ante.
Many thanks, Stijn. Helene, Ben, how do you see this? There are two aspects. What would be the difference if we shift from private bodies, autonomous systems, to the public authorities, which reaffirms or confirms this violations? And obviously it's also related on jurisdictions, whether it's EU law or UK law. But for the UK law, I imagine it's much less sensitive, the issues of free movement, as an example. So it won't, only competition law would be relevant. Is it a plausible scenario, and what would be the implications?
I was thinking of what you said, Ben, regarding this. It had national regulation contra, you know, we still need a level playing field. It's hard to have that if we have different national regulations. And then, of course, you would say, well, perhaps we should have some EU regulation on this. And then I think you mentioned that, Olis, that, and I forgot to mention that in the Super League case, that we also that dealt with Article 165 of the Treaty on the Functioning of the European Union, and basically the powers and the competence of the EU to regulate and to legislate, and we know that when it comes to sports, the EU has supporting competence rather than competence to legislate. So I guess if we, I mean, in this case, in the Super League case, or it's obvious that we have the article, the competition rules kick in, we have the free movement kick in. But if we start regulating these issues, then I guess the argument that this is contrary to Article 6 of the TFEU or Article 165 is more valid, or what is your view on that? I mean,
if I may jump in, I mean, first of all, I think the Court of Justice in ESL gives plenty of openings, I think, for UEFA to still block a closed league. So I mean, it's not a free for all. The court does recognize, you know, that UEFA has legitimacy to protect an international calendar, etc., the openness of competitions, etc. So there is still scope to act. Yeah, we can replace private regulation with public regulation, and indeed we could do it at the EU level, not on the basis of Article 165, obviously, but maybe on the basis of Article 114. Essentially, if we see a risk that member states are going to introduce measures, so we need to protect the internal market. I mean, it's not unthinkable. The problem I see there, you know, if you're going to protect the monopoly of the sports governing bodies beyond the openings that the Court of Justice still leaves, then I would say then it has to come with very strict good governance standards. You know, it should be a give and take, but it's possible. The difficulties I see is that, first of all, should this be a priority of the EU? I mean, we can discuss that, but also who's going to enforce all of that? How are we going to ensure compliance? Are we going to set up a whole, you know, a body, a unit, an entity that's going to ensure compliance? That's going to be a challenge. And then I also wonder, and now thinking also about the UK initiative, this is about men's football. So is it legitimate that the EU would only legislate in the area of football and then disregard all other sports, women's football, but you know, all other sports that might also benefit from better governance standards? So there's a lot of challenges, I think, in legislating in this area at EU level or also at the national level.
Is there anything more important than men's football?
I remember the catchphrase that football is the most important of unimportant things. Yeah. Somebody mentioned it during this previous wave of hype about this professional sports league. Let us about the competition law. Stijn, you have alluded already that we have new, the Court of Justice referred to kind of new criterion for object restriction or kind of borrowing from free movement. Can you elaborate more on this and maybe on other aspects as well?
Yeah, sure. I think that, and I read an article by Giorgio Monti on this as well, which I think is available on SSRN for students. And he says what the court is really doing here is it's almost defining three categories of object restriction. So one is kind of horizontal cartels. Two is other agreements that while not as bad for competition are still by object restrictions, and they kind of say where it leads to the exclusion of competitor, so Super League, right? And the third category then is partitioning of the internal market along national borders. Now, I don't think any of those three are new. Partitioning of national markets, that goes back to parallel trade cases. What is a bit new to me is this idea that this second category is somehow less bad for competition. I think that is a bit of a dangerous statement, to be honest, because if you look at the second category and where it comes from, it's the pay for delay cases, where essentially a new competitor was rewarded for staying off the market. And I don't really see how that is somehow better for competition than a horizontal cartel. I think, why do you need to, make that distinction in that way? I think what a better distinction would have been to say, okay, you've got kind of covert cartels that happen in a smoke-filled room or today in chat rooms or whatever, and you have things that perhaps sit in what looks like a legitimate agreement, but which actually have the same impact as those covert cartels. But then looking specifically at the case Royal Antwerp, what I find more difficult again is it's very unclear to me what competition is being restricted with this homegrown player rule. I can see certainly that it has an impact on the purchasing market, right? So the market for the recruitment of players. But as I said, like it can kind of go both ways. What happens to the prices that players can command if you make the number of places available to foreign players more scarce? And so that to me indicates it shouldn't really sit in the object box. Doesn't mean it's not a restriction, right? I mean, you can definitely still have restriction by effect there. And restriction by effect can be very bad. It can have huge impact on an economy. Look at the interchange fees cases. But to say that you can just look at the homegrown player rule and say, oh yeah, that is obviously a by-object restriction, to me stretches it a little bit. I have to say, I found that quite difficult. But it is what the law says right now, right? So it's not really for me to disagree with our highest court. But yeah, it's a difficult one, I think, and we'll have to see how the national court applies this. That will be interesting to follow that Belgian case.
Thanks indeed, Stijn. Helena.
Yeah, I agree with you, Stijn, on this. I think that it's not obvious that it should be by object infringement. Of course, it makes life easier for the authorities, but by effect could also be very detrimental to competition. And perhaps we should, as the court says, the by object restriction should be construed very narrowly. So I think they should perhaps have stuck to that here as well.
Many thanks, Helen. And when you were talking a lot in your writing and in presentations about voters' elements, how how different and how much of this doctrine has been applied to these cases. Can you elaborate maybe on this aspect?
Sure. Yeah, I guess, I mean, the court is now bending its over backwards now in two more recent judgments to say that we should have always known that the Wouters exception is not applicable when there's a restriction by object. I have my doubts, but okay. We now know that is only available for restrictions by effect. I think that was a wholly unnecessary move. If something causes a lot of anti-competitive harm, then that should have been part of the proportionality assessment. I guess the Commission's ISU eligibility rules decision is a good example of that. So I don't think it was necessary. But okay, that's the law now. I think then, secondly, that it's problematic, because we've just had this brief discussion about, you know, when is something an object effect restriction? And in the world of regulatory restrictions in sports, with so few precedents, it's really difficult. So a consequence of this is now that at least whenever it's not 100% certain it is not a restriction by object, you end up in Article 1013. And I think in comparison, I mean, I always saw the Wouters exception actually as a good framework to deal with this very limited amount of cases where you have private regulations and public interests, and there you do a rule of reason means ends test. I always saw that as a more suitable framework than going to 1013. So yeah, by narrowing the Wouters exception, we risk having to go to 1013, and it's just not a great fit in the sense that if we would open up Article 1013 and also invite public interest considerations there, as we might have done before 2004, then there would not be a problem. But the court is not going in that direction either. And it's actually endorsing the Commission's guidelines. You know, it has to be about economic efficiencies that are objective, quantifiable, etc. So I think that is problematic. The unclarity about the object effect classification now means that we might end up in a 1013 framework, which for these types of assessments, I think a cost-benefit analysis is less suitable to measure, you know, whether something is inherent or proportionate to a legitimate objective. So that's unfortunately the consequence of the court's clarifications regarding the Wouters exception here.
Before we get into recommendations to students, Stijn, Helene, do you want to elaborate on these aspects, 1011 or 1013?
Yeah, I think what Ben was saying is totally on point. And you know, if you think about where Wouters comes from, right? You know, these are also in a way rules that exclude others from a profession, and for very good reasons, right? I mean, for very good public policy reasons. But if we take into account this additional categorization of object restrictions that the court is making, whereby the second category involves, you know, exclusion of competitors, I can see that this becomes quite a difficult area to interpret and to apply in practice for any organization that you know sets rules for access to a profession or to a tournament or to a market, whatever it is. So, and I agree with Ben that, you know, approaching that only through the 1013 framework is unhelpful, and you know, yeah, means that there's not much scope for very legitimate public policy considerations that I do think should play a role when assessing those rules.
Thank you, Stijn. Helene?
Yeah, I agree. So, but this speaks even more in for a very narrow interpretation of by object restrictions then, I guess.
Thank you.
And maybe one difficulty to add, if you read through the three judgments, the court emphasizes constantly we have to have a consistent approach when we apply 101, 102, free movement. The consequence of this is that actually it's going to matter whether you're going to invoke, I mean, if we talk about regulation of professional activity, obviously often both the free movement rules and the competition rules will apply. And then we're going to have a strange situation that if you invoke Article 101 or 102, you might end up in an 1013 framework where you have to come with economic efficiencies. And if you invoke Article 56, for instance, you're not supposed to invoke economic objectives. So you're still with that Wouter's-like test. So very strange what the court did there.
I imagine, and because these are three cases and all concern so many difficult trajectories where we can develop further our conversation. Before reverting to Sudan, I wanted to ask if there is anything specific which aspects of these three judgments which in your view require further elaboration or maybe mentioning at least, and if yes, we can do it now, otherwise we revert to recommendations.
One thing I would say is just, I really hope that when applying, the learnings from these judgments, I hope that organizations like UEFA, but also in other sports, will do that in a transparent way and will allow, stakeholders to comment on what they plan to do, because I think that is essential and is something that is lacking if you are in a self-regulated environment. And it's a way for them to show legitimacy of what they are trying to put in place. So I hope that this doesn't happen behind closed doors, but in an open way, allowing people to comment and to really debate the learnings from this.
You say, Helene?
No, nothing to add. I agree with you on this, Stijn, and I really hope that they take the opportunity to do this, not behind closed doors, but in an open and amicable environment.
Ben?
Yeah, I think Stijn made an excellent point. I mean, if there's more input legitimacy, then I think we can defer more to the expertise of the governing bodies, that the outcome is actually, the least restrictive and the best possible way to deal with certain issues. So yeah, I think a lot of sports governing bodies should give more space for athlete commissions, etc., to secure that input legitimacy, and then hopefully the courts and competition authorities can also be a bit more deferential to them.
Great. So the majority of our listeners are students who do competition law, and then obviously they face this important milestone in their life after they graduate, what to do and mainly how to do. In terms of what to do, we know our instruction, do competition law. But in terms of how, maybe you can share from your experience, or maybe from your observations of successes and failures, some maybe good helpful life hack or tip to them.
Oh, that's a big question, Alice. That was the biggest one of them all, I think. I would say, just from my own experience, I've been in academia. I started out in private practice, went into academia, back to private practice. And I think as a student, you should just follow your heart and really do what you want to do. I'm really happy with the choices I made. And I didn't really follow the path that everyone else does, but that's been good for me. So I guess it's my life hack or tip or whatever you want.
Thank you very much, Helene. Stijn?
Yeah, I agree. Get involved, do different things. Don't ever think that whichever route you've picked is the one that you're going to be stuck in. Keep speaking out as well. And I think something like what Ben did, filing a complaint, even though he works as an academic, I think that's fantastic, right? And there's absolutely no restriction. People should get involved in the debate. People should make sure that the European Commission picks up the right cases. I think competition law is a very welcoming environment for that. So never feel like you're stuck in what you're doing straight out of university.
Thank you, Stijn. Ben?
Well, I'm not sure I would recommend everyone to file complaints. because as you can imagine, it was also an uphill battle to convince the commission to take this case. But I mean, I had a good experience, so that's true. Maybe to build on what was said, in terms of career paths, I occasionally get the question from students, you know, I'm interested in sports law, or particularly competition law in sports. What should I do? Where should I go? And I mean, obviously, let's be frank. There's very few people that on a full-time basis deal with competition law in sport or EU law in sport. But there's limited opportunities where you do touch upon this. So yeah, my advice there would be, I mean, as you might also, you know, recognize this, students are often, you know, worry a lot that, you know, the grade for this course or their thesis or their first internship is going to be career defining or career limiting, and it's not. There's many pathways, as my colleagues have said, and yeah, so for in this area, I would say first try to become a good competition lawyer. And then hopefully you will have at a later stage an opportunity to specialize and go to this niche, but don't try to aim for this niche already from the beginning, because it's going to lead to frustration. And also, I mean, the best sports lawyers that I know are the ones that have a very sound experience and knowledge in a certain field, whether it's tax law, competition law, or labor law, and then occasionally apply that to sports cases. So yeah, don't think too much ahead. Don't try to plan too much, and yeah, try to become a good lawyer, and then hopefully you will find your way in this niche or in other areas.
Thanks, Ben. Stijn Huijts, Helene Andersson, Ben van Rompuy, thank you very much indeed for your time and for sharing your brilliant ideas with all of us. It was a pleasure to see you today. Thank you.
Thank you.
Thanks.